Florida just passed new laws changing its foreclosure process for the first time in years. Whether you're a homeowner, investor, or lender, these changes will directly impact you. Today, I'm going to break down these changes and explain how to use them to your advantage. The biggest change in Florida's foreclosure laws is the expansion of something called the order to show cause. This new provision is designed to speed up foreclosures and eliminate long court trials. But what exactly does that mean? In the past, foreclosures in Florida typically took around 6 to 9 months to complete. Under these new laws, that timeline should be cut significantly. Here's why. The law now allows any lien holder, not just the primary lender, to request an expedited judgment through an order to show cause. This means condo associations, HOAs, and other lien holders now have the same power that was traditionally reserved for the primary lender. Let me walk you through how this new process works. First, a lien holder files a foreclosure. Once filed, they can request an order to show cause. The court then reviews this request in chambers, meaning there's no hearing required at this stage. If everything is properly documented and verified, the court will issue the order. This is where the timing becomes critical. The court must schedule a hearing at least 20 days after serving the order, or 45 days after serving the initial complaint, whichever gives more time to the property owner. If service is done by publication, there's a minimum 30-day waiting period after the first publication. It's important to note these timelines are not flexible. There are strict requirements under the new law. Now, if you're a property owner on the receiving end of an order to show cause, you need to understand your rights and obligations. You have until the hearing date to file your defenses, whether through a motion, responsive pleading, or an affidavit. But here's the critical part. Your defense must raise legitimate issues. Simply saying you disagree is not enough. You need specific facts or legal arguments that would prevent foreclosure if proven true. And this is a change from the past where people could file anything to really just delay the process. If you don't respond or appear at the hearing at all, you're considered to have waived your rights. The court can enter a default judgment against you, and you could lose your property without ever presenting your case. The new rules also streamline how attorney's fees are handled. For mortgages that provide reasonable attorney's fees up to 3% of the principal amount owed, no separate hearing is needed to determine if these fees are reasonable. While this might seem like a minor detail, it removes one more potential delay in the process. Now let's talk about what has not changed under foreclosure law. Florida remains a judicial foreclosure state, meaning all foreclosures must go through the court system. Lenders still must prove their case. They need to demonstrate proper standing, show the default, and verify all documentation. The burden of proof has not shifted. The process has just been streamlined. Property owners still have important rights. You maintain your right of redemption, meaning you could stop the foreclosure by paying the default amount at any time before the property is sold. And after the sale, you have a 10-day window to object, but only for procedural errors in the foreclosure process. If you're a lender, these changes present clear opportunities. The streamlined process means lower holding costs, reduced legal expenses, and less overall risk when lending in Florida. However, proper preparation is more important than ever. Errors in documentation can still cause significant delays. And if you're a property owner, these changes mean you need to act quickly if served with foreclosure papers. The expedited timeline leaves less room for delay in seeking legal counsel or preparing your defenses. While you still have the right to present defenses, negotiate loan modifications, or pursue alternatives to foreclosure, the window for taking action is shorter. And if you invest in foreclosed or distressed real estate, this is great news for you because it's going to present a whole bunch of new inventory on the market quicker than before. This is one of the most significant changes to Florida foreclosure law in a long time. If you're involved in Florida real estate in any capacity, as an owner, investor, or lender, you need to understand these new rules. They fundamentally change how foreclosures work and could significantly impact your property rights or investment strategies. Remember, while these rules make foreclosures more efficient, they don't eliminate your rights as a property owner. They just make it more important to act quickly and decisively when facing a foreclosure situation. If you like this video and want to stay on top of the latest real estate news, hit the like button. Let me know what topics you want to learn about next. Thanks for watching, and don't forget to subscribe for more videos every week.